That's right. The ayes are 105, the noes are 16. Clause 1 will stand part. The question is now is that Clause 2 stand part? I give the call to Brendan Horan.
Mr Chair, thank you. I rise to speak to the International Finance Agreements Amendment Bill and to the Supplementary Order Paper 175 standing in my name. Sir, as the bill has been written by the government, the commencement date is entirely open. The bill would come into force on a date set in an order in Council, and that sounds good enough, but the bill lacks a default specified commencement date that is now the usual drafting practice. And that means that the bill, when enacted, could wait 10, 20 years or even longer before coming into force. Will it still be relevant then? And it's not a hypothetical problem. The Parliamentary Council Office annually publishes a list of acts not yet in force, which do not have a specified default commencement date. On the latest list, there are 38 such acts which are, in whole or in part, not in force. And the oldest is the Summary Proceedings Act of 1976. So Parliament passed a law 37 years ago, and part of that law is still in limbo. Is that acceptable? So this International Finance Agreements Amendment Bill should not be another of those blank cheque bills. When Parliament passes legislation, the resulting acts should be brought into force within a reasonable and definite period of time. The Order in Council process allows the government of the day some flexibility to ensure the implementation can be conducted to deliver a good public policy process, sir. But surely that flexibility must be backstopped by a default specified commencement date. Sir, I'm aware that there are issues around treaty-making powers of government, the desire to avoid a vote in Parliament and recent developments since 1996 to provide some opportunities for scrutiny by our Parliament's select committees. And, sir, the Principal Act is unusual in that it enshrines in New Zealand legislation the nuts and bolts structure of an overseas body, and in this case the International Monetary Fund. But that's an argument for another day. Today, sir, I am focusing on the issue at hand, and that is if Parliament passes a law and the time that it takes for Parliament to pass that law and the work and energy that's gone into that by many groups and parliamentarians, then surely the government is obliged to reasonably bring it into force. And it's not necessarily an academic debate. Amongst the 38 acts not brought into force are 2 domestic violence acts, sir, and 2 acts regarding family courts. And so this is a real issue because too many children in New Zealand are children who do not choose to be victims of neglect. These children do not choose to be absent of a loving home, and these children do not choose to be victims of violence. And this government continues to leave the legislative solution in limbo, not being brought into force. Sir, ministers are not allocating public funding and are not taking policy decisions. And, sir, I would draw the House's attention to the Ministry of Justice, Care of Children Amendment Act. And if we look at the departmental comment around SS 5 to 8, 10 to 13 and 18 to 21, it reads as such: relates to agreements between parents and guardians, duties of lawyers and courts with regards to reconciliation and conciliation, disputes between guardians that lead to mediation or counselling, the mediation and counselling process, and appeals to the High Court and Court of Appeal will come into force on a date to be appointed by an Order in Council, needs operational policy development and additional funding to bring it into force. And if we go to the Family Courts Amendment Act 2008, and, sir, the departmental comment on this relates to the appointment and powers of senior family court registrars, and amendments to S8 inserting mediator after counsellor will come into force on a date to be appointed by an Order in Council, needs operational policy development and additional funding to bring it into force. And so one more that I'd draw the House's attention to, the Family Proceedings Amendment Act of 2008, Mr Chair,
Brendan Horrocks,
relates to the counselling and mediation process and rules under the Act, and at the end there, sir, needs operational policy development and additional funding to bring it into force. Sir, the National Government has taken advantage of this blank cheque written them by previous parliaments in the form of an open-ended commencement date. And, sir, I take into account the comments from the Honourable David Parker. However, sir, we cannot have open-ended start dates for any act, and therefore, sir, I commend this amendment to the House.
Dr. David Clark.
Mr Chair, I rise to speak to Clause 2 in respect of the commencement